attorney Laura Anthony, founding partner of Anthony P. LLC, a full-service corporate securities and business transactions law firm. Today is a continuation in a LawCast series talking about Form S-3 eligibility. Today we are going to talk about Instruction 1B6, which is known as the baby shelf rule. For companies that have an aggregate market value of voting and non-voting common stock held by non-affiliates of less than $75 million, Instruction 1B6 limits the amount that the company can offer on a Form S-3 to up to 1/3 of the market value in any trailing 12-month period. This 1/3 limitation is known as the baby shelf rule. The baby shelf rule is only available to companies that have at least one class of securities listed on a national securities exchange. It is not available to companies that trade on the OTC markets. To calculate the non-affiliated float for purposes of S-3 eligibility, a company may use the last sale price or the average of the bid and ask price on any date within the last 60 days. The registration capacity for a baby shelf is measured immediately prior to the offering and remeasured on a rolling basis in connection with subsequent takedowns. The availability for a particular takedown is measured as the current allowable offering amount less any amounts actually sold relying on the baby shelf rule in prior takedowns. Accordingly, the available offering amount will increase as a company's stock price increases and decrease as the stock price decreases. Also, if the aggregate market value of voting and non-voting common stock held by non-affiliates equals or exceeds $75 million after the effective date of the Form S-3, the 1/3 limit will no longer apply, and instead, the registration statement will be considered filed under the full shelf registration provisions in Instruction 1B1. In making the calculation where derivative securities had been sold, the company should multiply the aggregate market value of the underlying equity by the maximum amount of common shares that the derivative securities can be converted into. The market value of the underlying common equity can be determined using the same per share price used to determine the market value of the non-affiliated float. If the derivative securities have been converted or exercised, the aggregate market value of the underlying equity is calculated by multiplying the actual number of shares into which the securities were converted or exercised into by the market price of the shares on the date of the conversion or exercise. To rely on this instruction, the baby shelf instruction, to conduct an offering, the company cannot be a shell company and must not have been a shell company for at least 12 months prior to utilizing the Form S-3. In addition, if the company had been a shell company at any time previously, it must have filed Form 10 information with the SEC at least 12 calendar months prior to using the Form S-3, indicating that it was no longer a shell company. On November 2nd, 2016, the SEC issued a CNDI clarifying the calculation of the 1/3 limitation under the baby shelf rule in cases where a company was doing a concurrent registered offering and private placement. In particular, some companies were effecting an S-3 shelf takedown with an investor while simultaneously completing a private placement with that same investor and registering the private placement shares in a new resale Form S-3 registration statement. Although the shelf takedown was a primary direct issuance from the company and the resale registration filed on behalf of the selling shareholder, the combined effect was to use the Form S-3 for an amount of securities in excess of the 1/3 limitation. The workaround had become somewhat commonplace until the SEC issued the new CNDI, clarifying that it would no longer be allowed. In total, the CNDI provides, here's the question, an issuer with less than $75 million in public float is eligible to use Form S-3 for a primary offering in reliance on Instruction 1B6, which permits it to sell no more than 1/3 of its public float within a 12-month period. May it sell securities to the same investor or investors, with a portion coming from a takedown from its shelf registration statement, for which it was relying on Instruction 1B6, and a portion coming from a separate private placement that it concurrently registers for resale on a separate Form S-3 in reliance on Instruction 1B3. If the aggregate number of shares sold exceeds the Instruction 1B6 limitation that would be available to the issuer at that time. And the answer is no. Because we believe that this offering structure evades the offering size limitations on Instruction 1B6, the securities registered for resale on Form S3 should be counted against the issuer's available capacity under Instruction 1B6. Accordingly, an issuer may not rely on Instruction 1B3 to register the resale of the balance of the securities on Form S3 unless it has sufficient capacity under Instruction 1B6 to issue that amount of securities at the time of the filing of the resale registration statement. If it does not, it would need to either register the resale securities on Form S1 or wait until it had sufficient capacity under that instruction to register the resale on Form S3, i.e. Instruction 1B6. Although the SEC has made it clear that the private placement and shelf takedown shares will both count towards the 1/3 limitation when you have less than a 75 million market cap, a company can still conduct concurrent shelf takedowns and private placements with the same investor. In such case, the investor may either hold the private placement shares for the applicable Rule 144 holding period, or the shares can be registered for resale on Form S1. I'm securities attorney Laura Anthony, founding partner of Anthony P. LLC and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.